evening, everyone, and welcome to the RTI Center of Moneylife Foundation. We are indeed privileged to have two former Central Information Commissioners, Sailesh Gandhi and Professor Dr. Sridhar Acharyalu, to address us this evening. Welcome to both of you. What is unique about both of them is they were outspoken, prolific, and responsible for some outstanding RTI judgments that improved the act for all of us. Mr. Gandhi, of course, his tenure precedes Mr. Acharyalu. We also have with us Mr. Rangarao, who is a former Intelligence Bureau officer, keen proponent of the right to information, and technical. He is going to moderate the session. Mr. Rangarao is also an advisor on RTI to the Public Center for Governance Trust. Our primary goal at Moneylife Foundation is to spread financial literacy and help spread awareness about the RTI Act. Before I introduce our speakers and hand it over to them, I think I need to spell out a few ground rules. We've kept all of you on mute during the session for the benefit of those involved. We will unmute you during the Q&A when you are about to ask a question. For optimal viewing, we request you to keep the webinar on speaker view. This meeting will be recorded and uploaded on YouTube, so if you miss any part, you can see it then. During the question answer session, you have the ability to press the raise hand button, which is available on Zoom. To ask, and Arvind will unmute you. Please feel free to use the chat section to share your comments, questions, and observations. But please try and send it on the public forum. Don't send us private chats, that becomes difficult to monitor. Also, finally, please note that your homes and background are visible. Switching off your video. Now the speaker is so if you want to protect your privacy, you can do that by just switching off the video part of your computer. Now let me introduce our speakers. We'll start by introducing Professor Sridhar Acharyalu. He likes to call himself a journalist. He's a prolific writer, but he's basically an academic at heart. Like I said earlier, he's a former Central Information Commissioner. He's now the Dean of the School of Law at Bennett University. He's also served as a professor at Nalsar University of Law at Hyderabad. And he's an alumnus of the Department of Journalism and Mass Communication at Osmania University. His tenure, like I said earlier, saw several landmark judgments on RTI, some of which he will be sharing with us today. I'm also going to introduce Sailesh Gandhi right now. All of you know him very well in Bombay, especially at Moneylife Foundation, where he's been leading our RTI activities for a long, long time. He's an engineer from IIT Bombay who ran a successful enterprise. He's now a full-time activist. He was CIC for almost 4 years, and he was prolific during his time, having disposed of over 20,000 cases. And he was also the first person to digitize the entire Commissioner's office. He's now likes to call himself a passionate activist back again. I think Mr. Acharyalu is the same. So with these few words, I hand it over to Professor Sridhar Acharyalu as our first speaker.
Thank you very much. Good evening to all of you. After 15 years of RTI experience, we are looking at the possibility of avoiding misuse, not from the angle of petitioners, but from the angle of officers. In fact, when I was working as commissioner, I was experiencing that most of the PIOs are using the exception clauses without any application of mine. That's a very, very serious problem I was frequently facing. I don't know whether the experience of other commissioners is different. I don't think so. And just they mention the provision and they forget about it. So that is the problem with the PIOs. The PIO is unfortunately entrusted with a heavy responsibility of defining and justifying the disclosure and non-disclosure. It's a very, very heavy burden placed on the PIOs, and they are not accordingly trained. They don't have independence, they don't have knowledge, they don't have experience, they don't have infrastructure, and so on and so forth. This, in my view, is a very serious stumbling block in implementation of the Right to Information Act, and that is the reason why they simply say, yes, we are not in a position to give you because it is barred by so and so provision. They don't even look at how the provision really stops him from non-disclosure, disclosure of that information. That is the problem. Then the burden of PIO is terribly increased with not with the number of the cases, but with the amount of discretion that was imparted on him by the Supreme Court in 2019 judgment, November 13 judgment. The PIO is now expected to understand the terminology, language used by the petitioner, and then think about the probable and possible consequences of disclosure, and then understand the nuances of entire RTA enactment and follow the principles of interpretation as the Supreme Court does, and then decide whether he has to approach competent authority to decide the larger public interest or approach the public authority to decide the larger interest. This is the problem. So though there is an exception to exception called public interest, they are not in a position to exactly apply the test of understanding the public interest. As they fail to understand and apply the test of public interest, larger public interest and comparative public interest, the provisions of RTA, exception provisions of RTA under Section 8 are not properly used. Either they use it without application of mind, or they misuse it, but they very rarely they will understand the implication of the public interest. There are 2 or 3 levels of public interest that is required by the Right to Information Act to justify the disclosure. If you find section, if you read Section 8, you will understand that for some provisions there is a larger public interest prescribed as an exception, not to all, and some of them are supposed to be decided by PIO. Some of them has to be tested or declared to be disclosable by the competent authority. This is the dichotomy. Then that means what? He is not independent. He is under the instruction of his superior officers by law. This is one general limitation that we should understand on the functioning of public information officer. Then go to Section 8.2. It's a very, very interesting, important, effective tool which is not used at all. If you divide or classify the activity of PIO into non-use and abuse, I say Section 8.2 is subjected to non-use. They never use it. Then Section 8.1 with where public interest is a possible possible gate that can open for the disclosure, they don't understand, they don't use. So Section 8.2 operates a general comparative public interest quotient to all exceptions without an exception. That means from A to Z, A to J, you can weigh both the public interest to be protected by non-disclosure and public interest to be protected by disclosure. It's a very, very wide discretionary power giving provision, Section 8.2. It applies to all exceptions listed under 8.1. This is a very, very important factor in my view, which I think very rarely a PIO uses, or the Supreme Court also went into that aspect at all. Supreme Court did mention somewhere like that, but they are not totally examined. That's what I feel after studying the 250-page judgment of Supreme Court in 2019. That is my understanding. Then apart from the listed restrictions, there are several judgments. Let me tell you, there are several judgments which say that you cannot deny the information except under 8 and 9, Section 8 and 9. This statement was made by several judges in several cases, but that is not the case today. With 2019 judgment, the scope of restrictions increased to Section 10 and 11 also. Section 11 was profusely introduced by Supreme Court in 2019 in Subhash Chandra Agarwal case, saying that the confidentiality of the information is important. Confidentiality of which information? Whose information? Section 11 talks about confidentiality of third-party information. Except in the provision of 8.1, where commercial confidence is used, nowhere the confidentiality was used. No expression. There was no usage of this expression anywhere. But Supreme Court brought it. And they say confidentiality of government information. This is a most interesting expansion of scope of restrictions and increasing the scope of denial of the information. So that's the very, very serious problem with judicial extension of in 2019. It says, it draws the power, or I can say justification from preamble. In preamble, they say that we have to balance interest between right to information transparency and the confidentiality. That's what, along with others, they use the expression confidentiality. From there, they have taken it. And they went to Section 11. Section 11 talks about the personal information, personal privacy of the privacy and confidentiality of the third parties. So from there, they brought it. So they amalgamated these two, and they brought in a new ground of exception, that is confidentiality of government information. This is one thing. And then if you look at the Section 8.1a, which is supposed to deal with sovereignty, integrity, so on and so forth, we will generally stop with these two, but there are so many wide open expressions used in Section 8.1a, which includes economic interests. Economic interest. They used this expression of economic interest in denying any information about government. Suppose there is a government contract between government and a private organization. They deny, no, we can't give that information. No, it will adversely affect the economic interests of the nation. In fact, they say it will adversely, they also use Section 11. They combine it and say nation's economic interests will suffer, and then bringing in Section 11, they say the economic interests of the third party also will suffer. This is the new introduction in 2019. Then one more interesting part, is with reference to banks, Reserve Bank of India. Shailesh Gandhi has dealt with almost a dozen of cases where he logically, legally explained why banks should disclose the information. And it was challenged in a number of cases, and ultimately all those cases were transferred to by the Supreme Court to itself, and they have given a very comprehensive judgment in 2015, Jayanti Lal case. In Jayanti Lal case, I think this is the one of the most significant judgments of Supreme Court, which upheld the right to information in a very, very strong manner. It's a real vindication of the transparency in the financial institutions. It's a very, very important judgment. We can all be proud of that judgment. And all of the rulings in that judgment have upheld each of ruling by Shailesh Gandhi. So I take this opportunity to appreciate him, congratulate him for that wonderful ground he prepared, so that the Supreme Court was compelled to give a pro-RTI judgment. In the post-RTI era, I divide the Supreme Court's role into two periods, pre-2005 and post-2005. Pre-2005, Supreme Court is the supreme guardian of right to information, supreme supporter of transparency. The excellent judgments came up, and they protected constitutionalism, constitutional rights, and they also offered a wonderful tool called right to information, through which you can protect all other rights. Krishna Iyer was the champion of Right to Information Act, right to information, transparency. He wrote several letters to VP Singh at that point of time, asking for introduction of freedom of information bill. And he wrote a wonderful book. It is also, I don't know whether it is available, but it's a fantastic book every RTI lover should read that book. He explores the supporting aspects from the global perspective and pleads, advocates for the right to information. Whether it worked or not, the time and history speaks about it. We need not talk about it. Then it was 1981 in SP Gupta case. The first point of transparency arose out of judicial transaction. That's a very, very interesting point we should note. And about what? About appointment of judges and transfer of judges. When a transfer of judge and appointment of judge was raised as an issue, and the writ petitions were filed to challenging the appointment of a few judges and transfer of few judges, irrespective of result. We need not go into the facts of the case and result of the case, whose appointment is upheld, whose transfer is upheld, is not a relevant factor for us. But it is in that case in 1981, Supreme Court clearly stated that file notings and processing of the files for appointment of judges shall be in public domain. The very, very important, historic, interesting judgment of Supreme Court, which is not implemented till today, unfortunately. Not only that it is not implemented, but several spokes were introduced into it, and several limitations were added after that judgment. Unfortunate, very, very sad, unhealthy development, I say. Even today, the transparency in judicial appointments is a doubtful question. So what should I say? If at all anybody is misusing the authority vested in them because of their constitutional status, if they do not implement Right to Information Act, if they do not implement the judgment of Supreme Court in SP Gupta case, and if they do not implement the judgment of the Supreme Court in Rajnarayan versus Indira Gandhi case, what is that we can do? And if you examine today's standards of restrictions on right to information after 2019 judgment, I'd like to say the judgment given in 2002 would have been impossible. Today, impossible. Because the information about criminal conduct is private information. Information about educational background, marks, failures, adverse reports, private information. Information about the economic status, the income tax filings and everything, private information. Then where is ADR versus Union of India? Where is Union of India versus ADR 2002 judgment? You would have never got the information about contesting candidates, the criminal background, economic background, and educational background, three of which are now being treated as, unfortunately, private information. I'm not saying this baselessly. I request all of you to read section 50, paragraph 59 of judgment. Paragraph 59 of 2019 judgment lists the information that can be denied. Lists a very, very serious list, and I would like to read it. I will read it. Just a minute. Give me 1 minute. Let me access to my PowerPoint presentation. Very, very serious paragraph. I'll first of all, I'll read paragraph 59. Reading of the aforesaid judicial precedents. It quoted several judicial precedents before saying this. Reading of the aforesaid judicial precedents would indicate that personal records, including name, address, physical, mental, and psychological status. I can understand physical, mental, and psychological status, but tell me how name is private information. How name is private information. CV is for consideration or not? Is biodata for consideration or not? Are all treated as personal information. Similarly, professional records, including evaluation reports, disciplinary proceedings. Look at this, disciplinary proceedings. When disciplinary proceedings are taken up in an official capacity, when misbehavior during the official performance, misbehavior during the performance of legitimate duties is complained as a disciplinary proceeding, you consider it as private information. Terrible. Then These are all, they do not fall under privacy. They are being brought under privacy. That is the point I want to tell you. I'm not going from 81J to that area. I'm coming from their area to privacy. So they are, who said that these are all private information? Nobody said it. Supreme Court is saying. And are all personal information, medical records, medical expenditure also. Look at that, medical records, information relating to assets, liabilities, income tax returns are personal information, medical records. When you are enjoying the medical reimbursement from the public funds, how can that be a personal information? Such personal information is entitled to protection from unwarranted invasion of privacy, and conditional access is available when stipulation of larger public interest is satisfied. That is the only thing left out, larger public interest. And even today, I'd like to tell you, so that you do not get disappointed with all my speech, disappointing speech about misuse of restrictions. The life of RTI lies in Section 2F, Section 82, Section 81J, and Section 22. Life of RTI lies even today, in spite of so many misuses, so many interpretations coming from judiciary. Shailesh Gandhi was talking about one judgment of Gujarat High Court, or I think Gujarat High Court, which says that whether to give a copy of information, of a document, is a administrative job or judicial job, and they declared it as a judicial job. That means what? You have to go and argue for a record. It is against the spirit of Section 74 and 76 of Indian Evidence Act. Indian Evidence Act in the 1870s gave us right to information. Do you know what is it? 74 and 76. 74 defines public records. 76 offers access to public records with a nominal cost. They provided for seeking documents, copies of documents from the government, if it is a public record, by paying a nominal cost of copying. So the Right to Information Act in its seed form was available in 1870 to 73 when Indian Evidence Act was introduced. And only thing that was done by 2005 Act was they gave a legal guarantee to it. They provided a process for it. They have provided for a mechanism to acquire the information along with an appellate mechanism. So that is what is done. So if somebody asks you when do you get your right to information, I cannot agree with the answer of 2005. It is much long ago we got it. And I'd like to tell you why I am saying 2F is a very, very important section. You know, the last part of Section 2F, which was rarely used, I would like to tell you that which were rarely used. And if we can say among those provisions which are not used, this is a provision which is not used by the PIOs and by the CICs and by the state information commissioners. That is, if any information is under the control of private bodies, if any law provides for a access to that information, that is defined as information. Now, do you know what Supreme Court says today? Very interestingly, it agrees to it. 2F is a fantastic section, but it says here my point. Let me first tell what is my point on this as a law student and law teacher, law writer. My point is, once you bring information into the definition of information, the PIO gets is entrusted with the obligation to deliver that information, subject to restrictions under 8 and 9. But it is not subjected to any more restrictions. Now, what Supreme Court says is, the first part of Section 2F deals with information held by the public authorities, which has to be read with 22, Section 22. 22 says, all the laws existing legislations in the country, which are in force, if they provide a restriction or a provision not to give information, the Right to Information Act will override. This is the life, I tell you, this is the life of entire Right to Information Act. This life they could not meddle with. They, I don't know whether they wanted it or not. I don't go into their intentions. This is not proper on my part. But they could not do anything to this part of Right to Information Act. What they said is, even if any legislation, including Official Secrets Act, even if any legislation obstructs the disclosure of the information, it is not valid. Section 22 very clearly says that Right to Information Act will prevail. In my view, this is not properly used by the public authorities, especially misused by Reserve Bank of India. Because Reserve Bank of India misused it, every other bank also misused it. This was very strongly opposed by the Jayanti Lal Mishra case. Supreme Court very, very strongly stated it. But what RBI has done after that is a very, very sad history that we should understand, to understand the misuse of right to, or the misuse by the public authorities. They said that in spite of Jayanti Lal decision, the Board of Governors decided that certain information will not be disclosed, and that certain information is listed in Jayanti Lal case to be given. And they declared that this information will not be given. They declared, how a fantastic defiance of the Supreme Court order by RBI. And they announced it on their official website. They made it as a resolution of Reserve Bank of India governors meeting, and they instructed PIO not to give that information. When I was inquiring into compliance of an order of the CIC in giving information during the last year of functioning as Central Information Commissioner, I noticed that the website says don't give this information. Now the party insisted on issuing show cause notice and implementing penal proceedings. Against whom should I give? I know it is in public domain that PIO is not misusing that authority, but another authority, higher authority, is misusing that authority. They have exercised the provision available in 8.1 as a competent authority and public authority. There are two provisions. There are three authorities decide public interest in Section 8.1A. 8.1. One is public authority, second is competent authority, third is public information officer. So as a competent authority and public authority, RBI has decided that I will not disclose this information. And that is listed. And that has made me to give show cause notice to the governor of RBI. Why should I not consider that you are the person who is obstructing the flow of information in spite of the clearance given by Jayanti Lal case by the Supreme Court? And that created only a sensation. I could not pursue that case because I have my term is completed within a month of that, and they have successfully postponed the compliance of the order of CIC. That's a different thing. I'll not go into it. And another fortunate thing is L. Nageshwara bench, L. Nageshwara and another two judges of Supreme Court reaffirmed Jayanti Lal Mishra case, and then they said RBI and other banks have to give such information. They are giving, not giving, and you know all that. I'm talking about the misuse, the level of misuse at the higher level. We generally talk about PIOs, but I'm trying to give you the misuse of the provisions of law at the higher level. Then another important area of, I don't know what is the time given to me? Can I deal with fiduciary exception also? Do I have time?
Yes, sir. I think, yeah.
I cannot hear you. That's the problem.
Okay.
I'm not hearing you. Okay. Let me, somebody should call me and tell me what is my time, because I can't hear you. I don't know what happened to my computer. I was listening to earlier, but something happened. Okay. The fiduciary capacity. Fiduciary capacity means a person being in trust to protect the interests of the parties to the transaction and the others, and people in general. People in general. But the way governments and authorities have used it to say that Because I am fiduciary, I will not give any information to anybody. And they are creating the circumstances which will harm the interest of beneficiaries of the trust, and they use this trusteeship or fiduciary capacity to deny the information. In my view, this is the biggest misuse of the provision. Which biggest common misuse? Everybody does it. You take UPSC, they say, no, the answer sheets given by the students are given in fiduciary capacity. What fiduciary capacity? What kind of capacity it is? And in the Aditya Bandhopadhyay case, they really explained what is fiduciary. Very well done. Sanjay Khanna in one of the judgments explained what is fiduciary capacity. When he was judge of Delhi High Court, he gave a very good judgment explaining the restrictions. That is a very good judgment. Then what happened? Sucheta ji gave a message. Another 5 minutes. Okay, I know. I understand that I have 5 minutes. Okay. Then in fiduciary, there are two important judgments: Aditya Bandhopadhyay and Jayanti Lal Mishra, again to court, and they gave. And fortunately, the 2019 judgment also accepted Jayanti Lal Mishra. So that is the advantage. So the misuse of fiduciary capacity provision should not arise, should not be there. Now, I don't want to talk about contempt of court and parliamentary privileges because they are common and there is much less scope about discussing that. But let me tell you another interesting new area of restriction introduced by the Supreme Court in 2019. One is I told you, confidentiality of the government information, which I don't know what to say about it, which is prone to be misused tomorrow by several people. Then another feature is judicial independence. Judicial independence is another ground of non-disclosure of information according to 2019 Supreme Court judgment. It's a new thing that nobody discussed it so far. As I was, and I have to thank you because of your invitation for me to talk on restrictions. I went much deeper into these aspects and studied, and I discovered judicial independence. They did not make any general statement in the judgment. They left it and said that the CPIO of the courts, they have to decide whether in the interest of protection of judicial independence, a particular information can be denied. And that was explained further in several paragraphs of 2019 judgment, which says, if there is an adverse report, against a judge, that should not be disclosed. If any recruitment or contract activity is going on, if any term in the agreement which might adversely affect the commercial confidentiality, economic interests of the third party, that also cannot be given. So this is the expansion given by the Supreme Court for these things. And another point of Supreme Court is motive. Motive of seeking information has to be explained by the party so that public interest question can be decided. There are two opinions about it, but I'm just leaving it. I'm just pointing it out that this is what is Supreme Court's judgment. And N.V. Ramana, another judge of Supreme Court, gave a separate judgment agreeing with the majority judgment in 2019. He imposed a burden on the petitioner to explain the grounds of public interest, whereas the earlier situation is the burden of proof to establish public interest was on PIO, but N.V. Ramana in his judgment has shifted it to the other. So the adverse reports and the expansion of the restrictions which might adversely affect the future selection processes, commercial interests, and others cannot be given is the crux of the issue. And one more point, I will conclude with this point. Section 9 talks about intellectual property rights, but let me tell you, they are not real restrictions. You cannot restrict under, at least only on trade secrets you can restrict, but you cannot restrict on copyright, because having a copy of the copyrighted book is an exception to copyright protection according to Copyright Act. Similarly, patent, information patented means what? Do you know what is the agreement in patent? agreement in patent is I will explain my discovery, but you protect my economic interests arising out of that discovery, so that any other person can pursue the research adding on to what you have discovered. That means patent, even the intellectual property right patent cannot stop your disclosure process. That is the point. In my view, Right to Information Act has to be supported by civil society and media, and it is supporting. I appreciate. Out of 5 estates that we have in our country today, 3 estates, judiciary, executive, and legislature, are trying to restrict the scope of information, whereas civil society, the 5th estate, media, the 4th estate, are supporting us. I wish some more estates will come into our support, and they'll expand the scope of disclosure, restrict the scope of restrictions, and we will be benefited in our democracy by more flow of information. Thank you very much for this opportunity.
Thank you so much, Professor Acharyulu. I'm afraid you can't hear me, but this was a very, very lucid presentation, and thank you for simplifying all those judgments for us. May I now welcome Shailesh Gandhi and ask him to take over, please?
The exemptions in the RTI, why are there exemptions? Philosophically, all information belongs to citizens, and therefore they should have access to everything. What you own, you have access to. But the logic of exemptions is that some harm may come to certain interests which the law believes should be protected, and that is why the exemptions. And I'm going to deal with section 81F to 81J. I would say that it's not misuse of the RTI Act, it is gross misinterpretation. There's a difference. Misuse of RTI, I could understand, interpretation can be wrong, but what the words of a law say are supreme. I've heard an argument by some lawyers and others that the Supreme Court, whatever the Supreme Court says is law. I beg to disagree, because then I don't need a parliament. What parliament says, if there is scope for 2 opinions or 3 opinions or 2 interpretations, then the Supreme Court can interpret. But I think without that, if they do not look at the words of the law, I don't think there's any scope for them to do anything. Okay. F covers information received in confidence from foreign government. This order of mine covers that. This is the only thing where there is no real argument. If information is given by a foreign government and if the PIO says it was given in confidence, you can't really argue. I had one of my fairly few orders where I had accepted exemption. MEA had said that there was an agreement with Saudi Arabia which some citizen wanted, and I had said yes, they can claim exemption under section 81F. 81G. Information, the disclosure of which would endanger the life or physical safety of any person or identify the source of information or assistance given in confidence for law enforcement or security purposes. In CIC 5540, Allahabad University case was before me. The Vice Chancellor had ordered an inquiry to be completed in 1 month. 7 months later, this information had been sought. And the PIO said it will endanger somebody's life or physical safety, which is complete fiction, and therefore it was overturned. Perceived harm must have a reasonable possibility. If there is no, you can't just say, kuch bhi ho sakta hai, koi maar dega, ye hoga. Central Vigilance Commission, complaint made in 2007, RTI filed in 2010, information about outcome and progress of the investigation was denied. The first appellate authority's comment was, I find that as per the information available in the relevant file of the commission in this case had advised initiation of major penalty proceedings against officials of Coal India. I find that the disciplinary proceedings against the officers of Coal India are still pending. That is, the authorities have not yet issued final orders, and therefore they said disclosure would endanger somebody's life or physical safety, which was stricken down by me and not accepted. This was a fairly interesting case. In 12557, Central Bureau of Investigation had filed a charge sheet against Reliance by CBI in the call rerouting case. It was alleged that call rerouting had been done illegally against the law by Reliance Infocom at that time. The query raised by the applicant was, charge sheets had been filed against the other directors by CBI, but not against Mukesh Ambani and Anil Ambani. So the query was, why were Mukesh Ambani and Anil Ambani not included in the charge sheet? PIO said this would impede the process of investigation. Now, this was ridiculous. Charge sheets had been filed against some people and 2 directors had been left out. So there was no question of any investigation or prosecution of offenders, and this is all that was sought. The other thing, of course, which they claimed is that because it's a question mark, I will not answer. In which I had ruled that question marks do not mean you cannot answer. Question is, if there is a record, if there is nothing on record to show why Mukesh Ambani and Anil Ambani were not included in the charge sheet, state so. If there is some reasoning, then this must be given. Directorate of Vigilance, Delhi government, names of those against whom sanction for prosecution was sought, was denied, saying this would impede the process of investigation. When sanction for prosecution is asked for, investigation is already over and there is no question of impeding. And the critical word is impede. Because an investigation is ongoing, information cannot be refused. It must be shown how it will impede. If you cannot show reasonably that there is a possibility of impediment, information has to be given. Similarly, there was in a case 8394, PI stated that notings expressed would be that a case was filed against somebody, there was a charge against somebody, and the case was being prosecuted in court. The person against whom the case was being prosecuted asked for information on the files of the file notings based on which the decision was taken to prosecute him. And the PIO said, oh, this would give him an advantage. My decision was merely because the truth as it exists on the notings will be placed before the court. It is not logical to assume that it will be considered impeding the prosecution. It would obviously look at everything that is placed before it and revealing it only assist the court in coming to the right conclusion. This is often used to deny information whenever something or an investigation. In 70% of the cases, people who have filed a complaint are seeking information about the progress of an investigation because no progress takes place. And this is used. It is laughable. A person who's filed a complaint will not ever impede the process of investigation. If anything, he's trying to ensure that the investigation carries on. Section 8.1i is a very fascinating exemption. Cabinet papers, including records of deliberations of the councils of ministers, secretaries, and other officers, provided that the decisions of the councils of ministers, the reasons thereof, and the material on the basis of which the decisions are taken, shall be made public after the decision has been taken and the matter is complete or over. The very fascinating one. Up to a certain point, information is exempt until a decision is taken by the cabinet. But once a decision is taken, the law requires the cabinet to ensure that public comes to know about such decisions and the material on the basis of which this decision was taken. A very interesting case had come before me. Nuclear Safety Regulatory Authority bill was presented to Parliament by the previous government. Then, of course, the bill lapsed because the Parliament was dissolved and the new government came in. But the PI had not given any valid reason showing that any harm could come to a protected interest. The PIO said that this cannot be given because it is a cabinet decision and the matter is not complete or over. We argued that it is matter of the decisions and the cabinet note was to determine whether to put the bill before the Parliament or not. And therefore, I had stated that this information must be disclosed because once the bill is presented to Parliament, it is the property of the Parliament. Cabinet had decided and the matter is complete or over. And in fact, I had gone further and said that the Department of Atomic Energy shall ensure that all cabinet note and all cabinet notes in future of the department where such notes relate to proposing a new bill to be tabled in Parliament must be made public within 7 days of the bill being placed in Parliament. The thought process of this Cap 8I was that until it is decided, it should be secret. But for example, when a bill is presented in Parliament, the basis and the reasoning based on which this bill is presented should be publicly known so that public could also discuss. Of course, this assumes that bills would be placed and really discussed and debated in Parliament. Nowadays, of course, bills up, even the parliament does not know what bill is going to be presented, and it gets passed within a day or two. But the idea of a democracy is that citizens must have a right to discuss and debate bills. They may not vote on it, but they must be able to express their opinions. That is the logic of this. 8.1J is a favorite with PIOs. Whenever they don't want to give information, they say 8.1J, and I'll give you the perverted logic based on which this is done. Information which relates to personal information, the disclosure of which has no relationship to any public activity or interest, or which would cause unwarranted invasion of the privacy of the individual, unless the something is coming in between. Unless the PIO is satisfied that the larger public interest justifies the disclosure of such information, provided that the information which cannot be denied to Parliament or state legislature shall not be denied to any person. Let's analyze this. Over 50% of the denials are based on 8.1J. Information could be denied, in my opinion, if it's personal information. Your name, your age, anything that you do relating to a natural person is personal information. But that by itself is not adequate. There are countries in the world that have exempted all personal information. India has not done that. Parliament took the trouble of giving certain other conditionalities to personal information. And disclosure has no relationship to any public activity or interest. 99% of the information in government records is public records. And they are the consequence of a public activity. They are not the consequence of a private activity. In rare cases, a private activity is recorded maybe with the government. That is what would not be covered by 8.1J. That would be covered by 8.1J. And disclosure has no relationship to any public activity or interest, or it is unwarranted invasion of the privacy of the individual. Now, this privacy word has been bandied very wrongly, and everything is private. My name is private, my age is private, everything is private. Unfortunately, in the Puttaswamy judgment, where a 9-judge bench sat and gave a huge, long judgment, declaring privacy as a fundamental right, they did not indicate what constitutes privacy, but we'll come to that. We'll take a look at the Constitution and see what privacy could be and what information could be denied. But there is a specific thing, because it was understood and realized by Parliament that an ordinary PIO or a commissioner or anybody would find it very difficult to define privacy, etc., and public activity, private activity. Therefore, an acid test was given only to 8.1J, provided that the information which cannot be denied to Parliament or state legislature shall not be denied to any person. In my opinion, this can only have one meaning. Whoever claims exemption under Section 8.1J, Public Information Officer, First Appellate Authority, Information Commissioner, or Judge, he must say, I believe this is personal information relating to an actual person, and disclosure has no relationship to public activity or interest, or it is unwarranted invasion of the privacy of the individual, and say that I would not order this information to be given to Parliament. That is the crux of this. And what is the basis of privacy? I'll just come to that. The only permissible restrictions in Article 19.1a are given in Article 19.2. I have fundamental rights under Article 19.1a, and they can be restricted only if it's provided for in the Constitution. Article 19.2 permits reasonable restrictions in the interest of the sovereignty and integrity of India, security of the state, friendly relations with foreign states, public order, decency or morality, or in relation to contempt of court, defamation, or incitement to an offense. There are only two words in Article 19.2 which would cover privacy, which is decency or morality. None of the other words can apply to privacy at all. Therefore, if disclosing some information would violate decency or morality, this should not be given. This should not be given to Parliament also, because the logic of it is if it's given to Parliament, it becomes public knowledge. And if there is a harm to decency or morality, then it should not be given to any individual. It should not be given to Parliament. And that is the basis of the Section 8.1J. This proviso, provided that the information which cannot be denied to Parliament or a state legislature cannot be denied to any person. Unfortunately, and it pains me to say this, a number of Supreme Court judgments, including the Girish Deshpande judgment, in which 8.1J has been made as a gold standard, they have omitted this completely. They have amended the law unconstitutionally, illegally. Parliament has to make the law, and this is borne out by various Supreme Court judgments. I would strongly urge everyone to start understanding. I have a parliament to make laws. Supreme Court can interpret when there is scope for interpretation, when there are 2 or 3 possible meanings out of the words of a law. When there is no such possibility, and I would challenge anybody to give me alternate meaning to this. Disclosures ordered by me were job applications, caste, income, education certificates, ACRs, applications for government jobs, passports, licenses, etc., etc. In the Swarup Singh Naik case, the Bombay High Court, sometime in 2007, before I became a commissioner, had ruled. I had filed the RTI application. I was asking for medical records of Mr. Swarup Singh Naik, a former minister of Maharashtra. He had defied certain Supreme Court orders and was sentenced to go and spend 30 days in prison. The moment he went to Thane prison, he complained of chest in the left-hand side of the chest, and he was admitted to KEM hospital and put in a very lovely air-conditioned room, and that is how he was spending his prison term. I had asked for his medical records, and Bombay High Court had accepted that this was in larger public interest, and B, this is information which would be given to Parliament of a convict. This was the basis declared by Bombay High Court. However, Bombay High Court also now gives a different tune, which is very unfortunate. 81J is now being sought to be made into a section for non-denial of information. And here is something else which shows you that the decisions subsequently are wrong. R. Rajgopal and another in 1994, the Supreme Court it's a clear ratio decision. A citizen has a right to safeguard the privacy of his own family, marriage, procreation, motherhood, childbearing, and education, among other matters. None can publish anything about these matters without his consent, whether truthful or otherwise, whether laudatory or critical. Fair enough. That covers privacy. Once a matter becomes a matter of public record, the right to privacy no longer subsists, and it becomes a legitimate subject for comment by press and media, amongst others. We are, however, of the opinion that in the interest of decency, an exception must be carved out to this rule, which is a female who is the victim of a sexual assault, kidnapping, or offense should not be subjected to the indignity of her name and incident being publicized in press or media, which is what Section 81J captures. If something would violate decency or morality, it should not be published. It should not be given. And the right to publish, right to information, and freedom of speech all fall under Article 19(1)(a). So similar restrictions would have to be applied across all three. In the case of public officials, it is obvious. Right to privacy does not exist. The remedy of action for damages is simply not available in respect to their acts and conducts relevant to the discharge of their duties. This clearly is the law of the land. And R. Rajgopal was in 1994. Girish Deshpande came in 2012. It did not even consider R. Rajgopal. It had a precedent given by a 2-judge bench. Girish Deshpande was a 2-judge bench, but it has effectively thrown R. Rajgopal out of the window. In my respective opinion, this is a per incurium judgment. It does not quote the law properly. It does not give any reasoning, and is becoming the standard for many other Supreme Court judgments. Question that some people pose is, since subsequent Supreme Court judgments accept the act as a precedent, it is not a precedent. If you take a falsehood and keep repeating it, just because everyone says, okay, I accept this statement, does it become true? I don't think it becomes true. A per incurium judgment being taken as precedent, it should have considered R. Rajgopal, it should have considered ADR PUCL. After that, if it had come to a conclusion, one could understand. Girish Deshpande did not come to such a conclusion, and therefore I would humbly submit then that cannot be a precedent. And citizens, and I'm explaining this, hoping that citizens everywhere will start arguing with PIOs, with First Appellate Authorities, with commissioners and judges who blindly say Girish Deshpande and therefore will not argue about it. This needs to be argued, this needs to be established. Otherwise, if this is allowed to continue, it can finish the Right to Information Act in the coming years. A2, Sridhar has dealt with. I would only like to point out one thing. There is no, in most decisions, when you accept an exemption under 8.1, 8.2e, then to rule that there's a larger public interest is a very difficult task. It is impossible that PIOs can perform that task. It is impossible that first appellate authorities will perform that task. Maybe the commissioner may. And out of 20,000 judgments that I gave, if I recall correctly, only in about 7 or 8 or maybe 10 maximum, I had accepted that an exemption applies. Where I don't accept an exemption, I may say there is additional public interest. But after accepting an exemption, to rule that there is a larger public interest, I would have done it in only 5 to 10 cases at best. Most orders of commission, I have not yet come across a single PIO's order which says there's a larger public interest in disclosure. 8.2 remains on paper in a certain manner. 8.3, and this is important to understand, A, C, and I are the only exemptions that remain after a 20-year period. Therefore, after 20 years are over from an incident, the other exemptions, 7 exemptions of the RTI disappear. It's like the 50-50 in the Kaun Banega Crorepati. Copyright, Sridhar is very well covered. And you can severe, but section 11 I'd like to touch on, and then I'll end this. Where a PIO intends to disclose any information or record or part thereof on a request made under this Act, which relates to or has been supplied by a third party and has been treated as confidential by that third party, the PIO shall, within 5 days from the receipt of the request, give a written notice to the third party of the request and of the fact that the PIO intends to disclose information or record or part and invite the third party to make its submission in writing or orally regarding whether the information should be disclosed. And such submission of the third party shall be kept in view when taking a decision about disclosure of information. Very clearly, this is not an exemption. Section 7.1 of the RTI Act also says the only information that can be refused comes under Section 8 or 9. Section 11 is a procedure. And let's understand this. I'm amazed and horrified by the fact that various commissions, PIOs, and the courts are treating Section 11 as an exemption, which it is not. It is not at all an exemption. And let's read this carefully. When the PIO intends to disclose any record, when can a PIO intend to disclose some information? Only when he has come to the conclusion that it is not exempt. If he believes it is exempt under Section 8.1a to J, he must say this is exempt and therefore I'm not going to give it. However, what was imagined was the PIO comes to a conclusion that this is probably not exempt. And it relates to a third party. So he tells the third party, he intends to disclose information and invite the third party to make a submission in writing or orally regarding whether the information should be disclosed. And the PIO does, and the third party does not get a veto. And such submission of the third party shall be kept in view while taking a decision about disclosure of information. So what is imagined is a situation where the PIO does not agree with the with the third party and gives him notice that he's going to disclose the information. 11, 2, 3, 4 read together provide for an appeal to be made by a third party also. If the third party was to be given a veto, there would be no question of an appeal. Therefore, this is not misreading. It is going against the law and making a hash of the law, which I would submit very humbly is illegal, and nobody can act illegally and against the law of the land as declared by Parliament. Parliament makes laws, you can interpret it. I can see no other interpretation to say that third-party information is exempt, and that is a wrong way of looking at the law completely. We have one of the best laws in the world. There's an interesting case before me which I'd like to, before I close. Passport applications. Somebody asked for someone else's passport application. This was denied, saying it's Section 11. They did not use the exemption, they said Section 11. The matter had got to court. It was another matter, not the one before me. And the passport office told the Delhi High Court, the Ministry of External Affairs, that When a person applies for a passport, we know his address. But after that, we don't know where his address is. So therefore, we cannot approach the third party, and therefore we shall not give information. And unfortunately, the Delhi High Court had ruled that if you cannot read third party, you don't give information. This was brought before me, and I had declared this as per incuriam and said the commission rules that if a third party's address is not located, it does not mean the citizen's right to information would disappear. Section 11 is a procedural right that gives third party an opportunity to voice an objection in releasing the information. It is evident that PI is expected to follow the procedure of Section 11 when he intends to disclose this information. This means the PI has come to the conclusion that the information is not exempt as per the provisions of the Act. This is very important. You cannot deny a fundamental right of a citizen to right to information because you cannot locate the third party. Some people have asked me, Mr. Gandhi, since you argue like this, why is there Section 11 at all? I was part of the team that was arguing this when the drafts were being made. The consideration was that the PIO may think of the interests of his organization and may apply the right exemptions, but he may not realize the harm that may come to a third party. And therefore, natural justice requires that the third party be given an opportunity of voicing his objection. But this objection has to be based on Section 8(1) only, on what the law says shall not be given. So therefore, he may convince the PIO that some exemption or some harm which the PIO was not able to envisage will come, which is covered by the exemptions. That is the reason for Section 11. Section 11, I repeat, is not an exemption at all. Section 19(5) in fact says that in any appeal proceedings, the onus to prove that a denial of information was justified shall be on the PIO who denied the request. As the law stands, the spirit of the law was that the citizen need not justify why he wants information. He owns the information. He's the ruler of this nation. Government is run on behalf of him. He legitimizes parliament and the state assembly, not the other way around. But unfortunately, this is not being followed. I would suggest whenever you are faced with an exemption claim and you believe it is wrong, argue how it is wrong. Though the law does not require it, without that it will be difficult. And if people do not agree with you and say, no, there's a court judgment, there is this judgment, please say that, sir, please give me your reasoning as to how I am wrong. Section 8(1) comprises of 380 words. Defend your right to information by understanding Section 8(1) and refute illegal denials. Read and understand 380 word Section 8(1) properly. That's all you need to do. You can get a lot of supporting judgments at Moneylife's website in RTI Judgment Series. Use it. Defend your law by reasoning that the law does not legitimize denial of information unless it is clearly covered. And public interest, I would submit, is a very difficult one to prove for most commissioners also, and no PIO will accept that. So try and defend your RTI request by claiming that it is not exempt at all. Thank you. Thank you very much. Thank you. I'm over.
Thank you for sharing, sir. So I think really kind of you to share. It was a very detailed presentation. Before that, I would now like to request maybe Rangarao ji to take us over. Okay. So over to you.
Yeah, good evening, all of you. Welcome to all the participants. Sir, before going to the question answer session, as Professor Acharya sir, are you able to hear us? Yes, sir. I think you are.
I can hear you.
Yes, sir.
I'm fortunate I could hear Shailesh.
Sir, you have quoted many judgments, of course, right from the attended also other sessions. You are more legal and legalese. And as Mr. Shailesh Gandhi also prefaced his this thing before, so now mostly the RTI applicants are bothered with one thing, sir. That is my experience also as an RTI user. Supreme Court itself ruled and overruled itself many times, and likewise high courts. What in those circumstances an RTI applicant has to do in case if PAO courts whatever the convenient judgment of High Court or Supreme Court, convenient to him, and skips the giving the information. How to reconcile? Who has to reconcile?
My point is on this question, it's really very, very difficult. We have to, we don't have I can say any judgments so far, except Jayanti Lal Mishra case, which of course you can use it for fiduciary.
Yes.
I tell you, Aditya Bandyopadhyaya and Jayanti Lal Mishra cases are very good for defending our fiduciary status. Number one. Number two, with reference to Section 11 and all these things, all are now guided by 2019 judgment. Because it's being a constitutional bench, its judgment operates as the law all over the country. So it is a big stumbling block. So my point is, you can defend yourself not by cases, but by Section 82, 81, as Shailesh Gandhi has rightly put it. You understand those 380 words of 81, and then you can definitely establish. Now, I tell you, in spite of 2019 judgment, in spite of Girish Ramchandra Deshpande, we still have the weapon in our hands, that is public interest. So not only that, what Shailesh has suggested, that you have to quote the relevant section and defend. But I say, in our own interest, we should also try to establish what is public interest in it. That will help us.
I'd like to add to what Sridhar has said. Let's understand, yes, it's a very difficult position where our Supreme Court is ruling to curb my fundamental right far beyond what the Constitution permits or the law permits. Having said that, we should have a clamor everywhere. Every RTI applicant should battle whenever a wrong rejection is given by quoting 8.1 or Section 11, and argue and force PIOs, First Appellate Authorities, commissioners and judges to give reasoning. Say that, sir, I'm saying this, please give me your reasoning why I'm wrong. You have the right to decide. And I believe such forums like this, there should be 500 or 1,000 such discussions all across the country. If we have 1,000 such discussions, I think the Supreme Court will also listen. It's not that Supreme Court doesn't listen. The LTBG case is a fantastic case where, because of public opinion, ultimately the Supreme Court has changed its position. And the Supreme Court also listens. We must be willing to at least make our voices heard. And some people say, no, you can't do anything against the Supreme Court. I'm not talking of doing against, but convincing the Supreme Court that the position is wrong. And then I tell people that we were able to throw away a foreign government. Can't we try and convince our own Supreme Court? I believe we can, and we should try.
Sir, then that's the only way. Can we take up some questions from the participants?
Yes, sir. So we can do that. There is a question that we have received from a Miss Ayushi Mishra. Her question is: the Reserve Bank of India is a government body, thus comes under the Right to Information Act. But what about non-nationalized banks like Axis banks and other private banks? How can we get information from them?
Section 2F, last part. And every bank is supposed to be regulated, governed, and regularly reporting to Reserve Bank of India. So through Reserve Bank of India and other regulators, you can have access and you can get the information. 2F, last part.
Thanks a lot for that, sir. We actually have a question from Mr. Girish Mittal. So Mr. Girish Mittal is a very senior activist, and it reminded me from the bank question. He's done a lot of work on getting information from the RBI itself. So, sir, Girish Mittal ji, can you please unmute yourself?
Yeah, I am unmuted.
Yeah, hi.
Yeah. Sir, Sridhar sir, my question is to you. You have quoted elaborately on Jayanti Lal Mistry judgment, and I am one of the petitioners in the Jayanti Lal judgment. And in spite of the Jayanti Lal judgment, the Supreme Court did not give the information. And then again, we had to file a contempt petition in Supreme Court. And contempt petition fortunately was upheld. Unfortunately, last year, December 2019, again a two-judge bench, I don't know how they arrived at a conclusion, and all the information all the good work which was done by the Jayatilal Mistry judgment was stayed. And again, we are back in Supreme Court. We have filed a recall petition. We are, with these behemoths, we are fighting a uphill battle. We have one lone ranger, Prashant Bhushan, who is fighting with his LNG, and everybody else are having big ammunitions and Rafales. And recently, in the judgment, I saw at least 10 senior advocates appearing on behalf of various banks. Harish Salve is also appearing. I mean, they have got so much of ammunition. What a poor citizen like any of us can do to defend our right in such with such grave adversity.
It's a very, very complex process that we are in, where Supreme Court is adverse to us, that a case nobody will fight. Where Supreme Court favors right to information, the organization, public authority will fight. So this is the what is a pathetic situation we have. And again, I'd like to tell you, if you have the understanding, the persons who can understand the spirit of Right to Information Act as commissioners, you will definitely get a wonderful success. So what we should do is, we should pressurize the government to appoint various eminent personalities from different walks of life to the posts of positions of State Information Commission and Central Information Commission. That will help us. Do you know what we are doing? We are asking for filling of the vacancies, but we are not strongly asking for filling of vacancies with eminent persons, not only from bureaucracy, but from other fields. We should have more emphasis on that point. Otherwise, the filling of vacancies is a very pleasant job for the government. They will rehabilitate so many retired persons. They will be very happy. But what we need as civil society is the persons who can understand the spirit of, and they have to prove. Suppose an officer is appointed. I'm not opposing the officers. Suppose an officer is appointed, they have to prove that he is for the transparency. This is his history. He is an eminent person who worked for transparency in public administration when he was in office. If that is the case, give him appointment. I have no problem. But otherwise, don't give. Then how do you assess the eminence, yaar? Eminence का assessment कुछ रहना है ना, कुछ भी नहीं है इसमें. So it is not merit-based appointment. So when you are when your State Information Commission and Central Information can suffers, don't expect Supreme Court will support you and the High Court will support you. So you must get a strong machinery for you, which is created for you.
Shailesh sir, can I request you also to comment a little on this? Because I think when you were the commissioner, you had passed a judgment on the RBI declaring some of their results.
No, all the Jayatilal Mistry orders are based on decisions given by me. But to Girish's question, the answer I'd like to give is create a murmur around the country. All of us need to look at it and say, instead of just complaining, yes, we've got a bad situation right now with the Supreme Court opposing us, but we must have the confidence that we are the rulers of this nation and create a buzz across the country. Create discussions around this country saying the Supreme Court is constricting the RTI Act beyond what is permitted by the law and beyond what is permitted by the Constitution of India. If we do that, I believe we can bring change. Unfortunately, most of us RTI activists are not looking at it like that. We are not looking at that perspective at all. And as Sridhar says, we need better commissioners. In fact, I would submit that we should have at least one open, transparent interview of the prospective candidates, which publicly can be seen. That itself would bring in people who understand the RTI Act. I'm also all in favor of saying that at least 20 to 25% of all RTI commissioners should be RTI activists, because that is a body of people who are really concerned. As you might realize, when the pandemic came, most information commissions went on paid leave without work. Whereas the RTI activists have become more energetic and have meetings across the country and are exchanging views and filing PILs and doing variety of things. That is what you need. Fire in the belly for right to information, fire in the belly for democracy, fire in the belly for Article 19(1)(a).
Thank you for that, sir. We also have Commodore Lokesh Batra, who has done a lot of work on the Right to Information Act. He's also done a lot of superb work. He had some comments to make. Lokesh Batra ji, can I request you to unmute and share your question?
Yeah, I'm already unmuted.
Yeah.
I have 3 points. I think Professor Acharyalu rightly spoke about the Supreme Court judgment of 93. I have a document, I don't know if I can share with, but I can read out. That is a case of, I'm just reading out the document. Subhash Chandra Agarwal and Supreme Court of India dated, order is dated 13th November. Now, they have already started public authority quoting the Supreme Court judgment by denying information. What they are saying is nature and content of the information, that they have to look into it before giving information. Consequences of non-disclosure, danger and benefit to public, type of confidential obligations, belief of the confident, reasonable suspicion. Now they want to suspicion also. Party to whom information is disclosed. They have to decide whom to disclose. Manner in which information acquired, public and private interest, freedom of expression and proportionality. This is the damage that particular the case which was being mentioned by Professor Acharya. It is really damaging. I have got a number of such reasons for not giving information on public authority. And that was Subhash Chandra Agarwal's case. So instead of people were very happy that Chief Justice of India comes under, it had damaged it more than what we gained. Further, now when we talk of, now I'm bringing out the one specific case of PM Care Fund, which everybody must understand. They are saying they write it under section 11 to third party, which is called head of the PM Care Fund, not the Prime Minister's office. Of course, he's located there. My point is, first is, even under section 11, first thing is the information held with the public authority whom you are filing itself is under RTI Act. Even if I have to believe that Prime Minister office claims that they are not under the RTI, the only information which public authority can deny what has been provided by the authority of so-called PM Care Fund, and I'm not using the word PM. Now, if that is the case, if one answer comes from under section 11 from the Prime Minister's office who is dealing with the PM Care Fund, that's why I'm not using the word CPI or anything, saying we are not under the RTI, but the public authority you are seeking is under the RTI. And if some, like whether it's FCRA or GOVIN or anything given, it is a kind of a favor given to a private body. If they think they are the private body, then it creates a large public interest. Let's say GOV is a public authority under NIC or METI. Now this kind of favor given to the private body, so-called claim to be private body, PM Care Fund, then it has a very large public interest, something who is encroaching on my house. Public authorities belong to people. As the Shailesh said, all information held with public authority belongs to people. Now that is another issue which we need to be careful about it. I'm not going beyond that, which all the act. This is what I want to very clarify. Clearly, that this should be very clearly and something should be written by Professor Acharyalu on this subject.
Lokeshji, thank you for the comments. And, I think we're going to have to take it over to our speakers. So now can I request Shaileshji and Acharyaji to maybe comment a little on this, because we also have other questions. So would it be possible?
Yeah, I totally agree with him on the point that if PM cares, even though it is claimed to be not a public authority, the PM is public authority, PMO is public authority, which is operating it. PM is public authority. So they have to answer that question. Absolutely, there is no doubt about it. So that's all. I appreciate what he said.
Yeah, thank you. Thank you for that, sir. I think we also have surprisingly, we have a public information officer who is here in our midst. His question
Yeah.
is, I am working as a PIO in a government hospital. I get many RTI from opposite parties asking for medico-legal report of compliant. Like in case of rape cases, opposite parties ask medico-legal report of rape victims. So what can I do in that case?
In my opinion, this is held by the hospital in a fiduciary capacity. This falls squarely in the region of fiduciary capacity and therefore should not be given.
Legal case also. Yes.
But I have a different answer to give. See, when investigation is dependent upon the medical legal reports, and if the crime has to be proved based on that, the report becomes a very, very important document. Unless you prove that it impedes the process of investigation, you cannot stop it. You are saying it is an opposite party.
Yes.
Suppose he is a defendant, that is, he is an accused person. He has every right to access that document according to criminal justice system. It cannot be denied.
But through
He has
court,
to
sir.
get it.
Through court.
That means what? You don't want it under RTI Act, and you don't want to agree that he has right to information.
No, but then he can.
That's not correct. That's what I'm saying. See, he has approached you under Right to Information Act. Now, to defend my case, suppose I am accused, to defend my case is in public interest. Every accused has to be given complete information to defend himself. That is public interest. So, in public interest, even if you say that it is private information, somebody's disease information, somebody's confidential information, you apply all your restrictions under 81A, 81A to Z. Still, 82 helps me. That's what I was telling you. 82 helps me, and it is my interest. That is, I have to prove that I am not a guilty person. Or if somebody wants to prove that he is a guilty person, it is his interest to prove the guilt of a person. So, in both the ways, it is a larger public interest, comparative public interest. He has a right to get that information. Absolutely, he has got that right to information.
And why can't it be got from the court, sir?
Huh?
Why should it be from the court through a court order? Why should a PIO decide on something that's a medical legal?
That means what? Now I'll answer this question. It's a very interesting question. And if you allow this, suppose you have an alternate remedy under different enactment or different law to get a document there. There are two fora, A, B. A he can get and B also he can get. So A, he came to you, you are a forum, you have to decide according to RTI Act. You will not do that. You go and get, you say, go and get out and get the information from a alternative source. Is that correct? You decide under RTI Act. That is my question. He approached you. He is before you. You tell whether you can give it or not. I am telling you, you can give it.
So the question is that if it is a PIO, whether the person who's asking is really a defendant, whether he has a right to get it, that's an investigation he will have to do before he makes up his mind. It could be somebody else who's pretending that, oh, so-and-so has accused me also. Suppose it's a gang rape kind of thing. There may be 4 other parties who may vaguely be connected, who may leak it to the media. You've seen what happened in the Rti case. All kinds of WhatsApps were being shared on television. I don't know whether the PIO is the right person to take.
To decide.
Yeah, I'm sorry.
I'd love to hear even, Mr. Gandhi's views, but I'm a little hesitant to agree with this.
That is because of I can only say that the criminal justice system is different. It is not a civil court where you can confide your documents. Criminal justice, crime itself is a public wrong. An entire judiciary is supposed to be transparent from day one FIR to till the judgment. And accused, not only accused, and the person who is interested in it. It is not only limited to the parties. That's the point I want to answer you. You wanted to know whether that fellow is a party or not, he is an accused or not. Suppose accused is coming, your problem is solved. Now he is a charge sheeted fellow. Charge sheet shows that he is an accused. He need not investigate. He deserves it. He is entitled to it. So according to RTI, he is entitled to. And if you deny according to RTI, I think it is against RTI. That's what I can say.
Thank you for sharing those views. So I think Rangarao ji has something to add to this.
I see
Yes,
Mr. Subhash Chandra has raised his hand. I think he has got some.
I'm not able to see
Mr. Subhash Chandra.
So Subhash Chandra.
Do you have any queries, sir? Yeah. Yes. Come on, please.
Yeah, Mr.
Unmute
Subhash Chandra ji,
Unmute.
can you please unmute and can you please share your question?
Unmute, please.
Okay, I think.
Yeah.
Yes.
Okay.
Yes, Commodore Lokesh Batra just mentioned about the verdict, which was about my petition of the 13/11/2019 Supreme Court verdict. Yes, the cover page was very beautiful. CJI office comes under RTI Act, but there were 2 more petitions inside that cover book. And surprisingly, in one of those petitions, I asked for file notings on superseding of Mr. Justice A.P. Shah. CIC remanded back the matter to the first appellate authority with the strictures that Supreme Court persons at Supreme Court should be given proper training for handling RTI matters. Anyway, I appeared before the first appellate authority at Supreme Court through teleconferencing, and I told us Mr. Justice Ranjan Gogoi, who was the Chief Justice giving the verdict, after retirement on his being nominated at Rajya Sabha, repeatedly in TV interviews said, file an RTI petition with Supreme Court seeking details why Mr. A.P. Shah was superseded. Surprising, when I raised the question with the appellate authority, he mentioned that रंजन गोगोई साहब ने जो उस समय जजमेंट दिया था वो चीफ जस्टिस की कुर्सी पे बैठ के दिया था, और बाद में जो बोले हैं वो पर्सनल कैपेसिटी में बोले हैं, तो दोनों में कोई मैच नहीं हो सकता.
राज्यसभा मेंबर की कैपेसिटी में दिया है. You're muted your mic. You have to unmute.
But his ruling as a Supreme Court Chief Justice will override as MP, Rajya Sabha or any other MP.
Ruling is the law, sir. The others are opinions.
Yes, sir.
And I want to give a small clarification, not a small clarification, a very big clarification rather. The entire media reported that CJI, Chief Justice of India's office, is public authority. But do you know what exactly the judgment is? Judgment says the entire judiciary is the public authority, and CJI as a part of it can be considered as public authority, but not as a distinct public authority as decided by Delhi High Court full bench. That is.
और उसमें क्या हुआ है, सेक्शन 11 की धज्जियां उड़ा दी गई. 13 नवंबर का जजमेंट था, विद इन 5 days थर्ड पार्टी नोटिस इशू होने थे, एंड विद इन बाय 28 December information must have been provided to me, but third party notices were issued only on 6 January 2020 after my reminding the CPIO, and then I had to send a reminder. What happened to my petition? Then they sent reminder to the third parties, and third parties are given only 10 days time. If they don't comment, then CPI has to provide information. Section 11 starts with the narration that in case CPI intends to provide information, only then he can seek comments. Now,
I'm really sorry to step in, sir. I'm sorry to interfere in the middle. I think we'll have to come to a wrap right now. It's 7:30. Before I can request Rangarao ji to take us over and give the vote of thanks, I just wanted to share a couple of other things. A lot of you have sent us messages here in the comments asking for some very specific questions. My request would be, please send us an email on foundation@moneylife.in, and we can try and resolve all your queries there, because our speakers won't be able to answer all of them here. And even the PPTs which you had requested for, please drop us an email. We'll try and answer them as much as possible. And anything else, you can check out our website, Moneylife Foundation, mlfoundation.in, and also do check out our YouTube channel for the recorded copy of this video. So that is it from my end. I will now request Rangarao ji to please propose the vote of thanks.
Mr. Rangarao, just
Yes,
1 minute intervention.
Yes, sir.
I am hoping that everybody realizes that we've got to fight illegal denial of information under Section 8(1), and it has to be done widespread.
Yes.
Merely talking about it will not change anything. And I'd like to end with a small story. The doyen of the RTI movement in Maharashtra was Prakash Kardale, former resident editor of Pune in the Indian Express. While the draft was being discussed, he and I once had a phone conversation which I'll never forget. He said, Shailesh, I think we should omit the judiciary from the domain of RTI. And I said, why? What's so special about the judiciary? We are including the Prime Minister, the President of India. Why should the judiciary be excluded? And he said, Shailesh, if we exclude the judiciary, we will get fantastic judgments on transparency and the RTI Act. If we include them, and I will not say the rest, but leave it to everyone's imagination. Thank you. Thank you.
I think he's right.
Yes.
Rangarao-ji, over to you now.
I take this opportunity to thank Professor Sridhar Acharyalu and Mr. Shailesh Gandhi for coming to this session and educating all of us and to take it forward the movement of RTI, the only weapon in the hands of the citizens of a democratic country to make the government accountable and transparent. There is no point in cribbing over the government's inefficiency or delays or corruption or anything like that. Whatever the tool has been given to us, the citizens, as per the Constitution. So the Constitution recognizes the citizen as a sovereign. So, and besides that, it has given the weapon also. Why can't we use it? So, in pursuance of our RTI users, champions, and activists, let's make use of the RTI Act in full, and then make our living better. I also thank this opportunity. Take this opportunity to thank Mrs. Sucheta Dalal and the entire Moneylife team. And they are doing a lot of crusaders in the RTI and other financial education, also literacy, imparting financial literacy to the citizens. And they're doing commendable job to bring about transformation in lives of the people. I also take this opportunity to thank all the participants to taking their time to come and attend. It shows that the fact that there are more than 125 participants are here shows that RTI has got a future. RTI definitely will live on, and then we'll bring about a good transformation in our country. Thank you.